Judge Adrian Holloway stood in handcuffs at a Tennessee gas station, surrounded by 3 officers. His expensive suit was dusty. One cop smirked. "Big mistake driving through our town, boy." This is one of those black stories that reminds us how quickly power can shift. Real-life stories do not always follow the script we expect. Beat stories like this one prove that touching stories can emerge from the darkest moments. Late at night on a rural route, fluorescent lights flickered overhead. Adrian, 52 years old, stood beside his black Mercedes S-Class. His charcoal Tom Ford suit caught the light. His hands were steady. His voice was calm. He said nothing as the cuffs clicked shut. Have you ever been so certain of your innocence that you stayed silent, knowing the truth would be louder than any defense you could offer? Officer Vance Whitaker approached with his hand near his weapon. 15 years on the force, crew cut, 38 years old, his boots crunched on gravel. License and registration now. Adrian reached slowly into his jacket. He pulled out his wallet. His movements were deliberate. Every gesture telegraphed compliance. Whitaker studied the license under his flashlight. Atlanta, long way from home. He looked up. Step out of the vehicle. Adrian opened the door. He stood. He kept his hands visible. Officer Bryce Langley circled the Mercedes with his flashlight. 29 years old. His body cam was off. The small red light that should have been blinking was dark. Nice car, Langley said. How's a guy like you afford a ride like this? Adrian did not answer. He watched. He calculated. Sergeant Victor Morales pulled up in a third cruiser, 45 years old. Supervisor on scene. He stepped out and surveyed the situation. He did not ask questions. He did not de-escalate. What do we have? Morales asked. Matches the description, Whitaker said. Description of what? Adrian asked quietly. Don't play dumb, Whitaker said. Robbery suspect, we got a call. Adrian's jaw tightened. What robbery? When? Where? Whitaker ignored him. Turn around, hands behind your back. The handcuffs were cold. They bit into Adrian's wrists, not painfully, just enough to remind him of their presence. Inside the gas station, a clerk watched through the window. Hispanic, 24 years old, college student, working nights. He had had his own encounters with Morales. He pulled out his phone. He started recording. 2 other customers stood at their pumps. Both pulled out phones. The cameras captured everything. Adrian's calm face, Whitaker's aggressive stance, the way Langley kept circling like a predator. One customer whispered to the other, "Think he actually did something?" The other shrugged. Cops wouldn't arrest him for nothing. Adrian was loaded into the back of Whitaker's cruiser. The door slammed. The world became smaller. Blue and red lights painted the night. His briefcase sat on the passenger seat of his Mercedes. Inside was a gavel-shaped paperweight. The engraving read, Judge Adrian Holloway, 6th Circuit Court. Nobody looked inside. They arrived at the county sheriff's department. Concrete walls, fluorescent buzz, the smell of industrial disinfectant. Adrian was placed in a holding cell. He sat upright. His tie was still knotted. He folded his jacket beside him. Desk Sergeant Ramsey processed the paperwork. 50-something. He had seen everything twice. His eyes were tired but sharp. Whitaker filled out the arrest report. Suspicious activity, failure to comply, possible vehicle theft. Ramsey raised an eyebrow. Vehicle theft. Registration came back clean. High-end car. Whitaker said, out-of-state plates, late night. Run his record. Ramsey typed. The system loaded. No priors, not even a parking ticket. Whitaker, Ramsey said slowly. Maybe we should... Morales interrupted. Book him. Disorderly conduct. We'll sort it in the morning. Ramsey hesitated. Then he printed the custody receipt. Personal effects. Wallet containing Bar Association card. Briefcase not open per protocol. Phone. Adrian watched this exchange. His face showed nothing. I'd like to make my phone call, Adrian said. Morales looked at him. Phone system's down. You'll call in the morning. That's a violation of... Don't tell me my job, sir. Morales's voice dripped with sarcasm. Adrian stopped talking. A slight smile touched his lips, the first time he had smiled all night. Whitaker noticed. What's funny? Nothing, officer, Adrian said. I'll wait. What they did not know, Adrian's absence had already triggered alerts. His court clerk expected a check-in call by midnight. His wife, a prominent civil rights attorney, expected the same. The State Bar Association had protocols for traveling judges. When judges do not check in, people notice. Adrian lay on the cell bench. His eyes were open. 3 rooms away, his phone sat in an evidence locker. It buzzed continuously, 47 missed calls. His watch caught the light. Patek Philippe Nautilus, $85,000. Whitaker had seen it earlier. He had assumed it was fake. His wedding ring had an inscription visible when light hit it right. To Judge Holloway, love eternal. Nobody had looked closely enough. A guard walked past. Adrian spoke softly. Officer, what's the date? August 1st. Why? Just keeping track, Adrian said. The guard left. Adrian closed his eyes. He knew the rotation schedule. Tennessee rotates visiting judges from other districts to handle overflow cases. He had checked it before leaving Atlanta. The visiting judge assignment was his. He smiled again in the darkness. Ramsey, the desk sergeant, came back to check on him. He stood outside the cell. You a lawyer? Ramsey asked quietly. Something like that, Adrian said. Ramsey nodded. He walked away, but he pulled Adrian's custody file. He read the Bar Association card entry. His eyes widened. He said nothing. Adrian's wife, Elena, called the county sheriff's office. The receptionist answered. I'm looking for my husband, Adrian Holloway. He was arrested last night. Hold, please. The line clicked. Silence. Then Morales's voice. Ma'am, your husband refused to cooperate. He'll see a magistrate this afternoon. This afternoon? Elena's voice was sharp. That's a 14-hour hold without arraignment. Morales hung up. Elena immediately called the Tennessee State Bar Association. The machinery was turning slowly, but it was turning. Adrian sat in his cell. His suit was wrinkled now, but his spine was still straight. His hands were still folded. He was the calmest person in the building. Elena called the Tennessee State Bar Association. She spoke with Director Patricia Carmichael. They're holding a judge, Elena said. Without cause, without his phone call, they don't even know who he is. Carmichael went silent. Then, which judge? Adrian Holloway, 6th Circuit. Oh God. The Bar Association called the Tennessee Attorney General's office. Chief Judge Lorraine Bennett learned her colleague was in custody. Judge Bennett had mentored Adrian for 2 decades. She had watched him rise from public defender to circuit judge. She knew his temperament. She knew his precision. She made one phone call. Don't release him yet. Let this play out. It sounded cruel. It was not. It was strategic. The gas station videos went viral. The customer who filmed it posted on Twitter with hashtags driving while black, the county name. A civil rights journalist picked up the thread. She broke down the timeline. Well-dressed man, full compliance, no probable cause stated, body cams off, matches description of what crime. None reported in the county that night. Local news called the sheriff's department. We're hearing about an arrest last night. Can you comment? The receptionist transferred them to Sheriff Dale Merrick. Merrick was 58, 3 terms, elected official. He had survived scandals before, but he felt something different this time. He pulled up the custody log, then the gas station footage someone had emailed anonymously. He watched Adrian comply. He watched Whitaker escalate. He watched 3 officers surround one calm man. Merrick called Whitaker into his office. What the hell happened? Routine stop, sir. He was aggressive. Merrick turned his computer screen. Watch this. Tell me where he's aggressive. Whitaker watched. His face tightened. Clips can be edited. This is raw footage from the gas station security system, time-stamped, continuous. Whitaker said nothing. Morales entered. His wife's raising hell. She's some kind of lawyer. Merrick made a calculation, political calculation. Cite and release, get him out by noon, disorderly conduct fine, $500. He'll pay and leave. Sheriff, do it. What Merrick did not do was check who Adrian actually was. He just wanted the problem gone. Adrian was brought to the magistrate court, basement level. Magistrate Ellis presided, 42 years old, part-time position. He handled minor offenses, standard procedure, name, charge, plea, bail. Adrian Jonathan Holloway. Ellis read. Disorderly conduct. How do you plead? Not guilty. Ellis set the hearing date, 10 in the morning. Adrian's eyes flickered just for a second. Bail set at $1,000. Adrian paid from his wallet. He collected his belongings, his briefcase, his phone, his watch. As he signed the release forms, he looked up at Ellis. Judge Ellis, are you familiar with Judicial Conduct Canon 3.2? Ellis blinked. What? You'll want to review it. Good day. Adrian walked out. Exactly 12 hours after his arrest, 23 reporters waited on the courthouse steps. Cameras flashed. Questions flew. Were you mistreated? Will you sue? Do you think this was racially motivated? Adrian stood at the microphone cluster. Elena stood beside him. He raised one hand. The crowd quieted. His statement was 100 words, measured, devastating. I am Judge Adrian Holloway of the 6th Circuit Court of Georgia. Last night, I was arrested without probable cause by county officers. I complied fully. Their body cams were disabled. I was denied my phone call. I have served 18 years on the bench. I have presided over 4,000 cases. I have never, not once, been on the defendant's side of a courtroom until yesterday. This experience has clarified something I thought I understood. I did not. No further questions. He walked to his Mercedes. He drove away. Within 30 minutes, CNN picked it up. MSNBC, Fox News. The headlines varied, but the shock was universal. Federal judge arrested at gas station. Judge held without cause. Body cam footage missing in judge's arrest. Back at the county sheriff's department, Merrick watched the news. His face went pale. Get me everything, he told his assistant. Every report, every recording, every piece of paper. The Tennessee Bureau of Investigation opened an inquiry that afternoon. 2 investigators arrived at the station. We need the body cam footage from last night's arrest. Whitaker sat across from them. Technical malfunction, all 3 cameras. Yes. Simultaneously. Yes. The lead investigator leaned forward. Officer Whitaker, the statistical probability of 3 independent devices failing at the exact same moment is 0.003%. Would you like to revise your statement? Whitaker said nothing. They pulled the jail security recordings, audio from inside the station. One clip caught Morales talking to Whitaker in the break room. You didn't tell me he had Georgia plates with a government exemption sticker. So what? Plenty of state employees have those. Judges get those. Whitaker, judges, we didn't know. The investigators listened. They made notes. They said nothing. The evidence was mounting. Gas station footage showed no disorderly conduct. Customer videos corroborated Adrian's compliance. Jail logs showed the phone system was operational. 3 other inmates made calls during Adrian's detention. Dispatch recording showed no robbery reported in the county that night. Match's description was fabricated. Judge Miriam Haskell, county circuit judge, called an emergency meeting with Sheriff Merrick. Linda Haskell was 62. Tough. Fair. She had served the county for 20 years. Do you understand what you've done? Her voice was quiet. Dangerous quiet. It was a mistake, Merrick said. We'll apologize. It's not your apology to give. You arrested a federal circuit judge. The 6th Circuit has jurisdiction over Tennessee. We didn't know. That's worse. You arrested a man without probable cause. The fact that he's a judge just makes it impossible to sweep under the rug. Merrick sat down heavily. What do we do? You wait. He scheduled his hearing. Do you know who the visiting judge is that day? Merrick shook his head. Check the rotation. Merrick pulled up the public schedule. His face went white. Visiting judge, Adrian J. Holloway. Oh, God. Yes, Haskell said. Oh, God. What neither of them knew yet, the Sixth Circuit had launched a formal review of the county's arrest patterns. Adrian's case was the catalyst, but data analysts were already pulling 5 years of records. Early findings showed a pattern. Black drivers arrested at 8.7 times the rate of others for suspicious activity. The numbers did not lie. Adrian spent the next 2 weeks preparing, not his defense, his prosecution. The day arrived with clear skies. The county circuit courthouse was built in 1932. Stone steps, tall columns, the kind of building that was supposed to represent justice. By morning, the gallery was packed. Media, civil rights observers, local citizens. Some came to support the officers. Most came to witness history. Whitaker, Langley, and Morales sat at the defendant's table. County Attorney Nolan Reed sat with them. He was 39, overwhelmed. He had been assigned this case days ago. He had spent those days trying to get the charges dismissed. His motions were denied by Judge Haskell, by the Attorney General's office, by everyone. Let it proceed, they all said. Reed did not understand why until this moment. The bailiff entered. All rise. The room stood. The Honorable Judge Adrian J. Holloway presiding. The door opened. Adrian entered in full judicial robes, black fabric, dignified. He walked with the same calm he had shown in handcuffs. His gavel, the one from his briefcase, rested on the bench. He sat. He arranged his papers. He looked up. Please be seated. The room sat. You could hear breathing. Adrian's voice was clear, steady. This is case number 2024, CR 1847, the State of Tennessee versus Officers Vance Whitaker, Bryce Langley, and Sergeant Victor Morales. Charges: deprivation of civil rights under color of law, false arrest, and falsification of police records. How did the defendants plead? Reed stood. His hands shook. Your Honor, I move for your recusal. Motion denied. Your Honor, Counsel. Judicial Canon 3.2 allows a judge to preside when the judge is a witness to the facts, not merely a victim. I witnessed every moment of the events in question. I am uniquely qualified to hear this case. Your motion is denied. How do your clients plead? Reed looked at the 3 officers. Whitaker stared at the table. Langley looked sick. Morales' jaw was clenched. Not guilty, Your Honor. Noted. Prosecution may present its opening statement. A prosecutor from the Attorney General's office stood. Elena Holloway sat in the front row. She was not prosecuting. That would have been too much. But she was there. The prosecutor laid out the case: wrongful arrest, civil rights violation, falsification of records. Then came the evidence. Exhibit A. Gas station footage played on courtroom screens, high definition, time-stamped, every second documented. Adrian narrated his own arrest. His voice was clinical, detached. Noted timestamp 234719. Officer Whitaker approaches with hand on weapon. At 234755, I provide license and registration without hesitation. At 234912, I am handcuffed without stated probable cause. The footage showed everything. Adrian's compliance, Whitaker's aggression, the way Langley circled the car like he was hunting. The courtroom watched in silence. Exhibit B, body cam audit. A TBI investigator took the stand. All 3 officers' body cams were manually disabled minutes before initial contact with Judge Holloway. Adrian looked at Whitaker. Officer Whitaker, is it standard protocol to disable recording equipment before a traffic stop? Reed stood. Objection. Leading. Overruled. The officer will answer. Whitaker cleared his throat. I don't recall. Let me help your memory. The device logs show you press the disable button 3 times in succession. That requires deliberate action. Did you or did you not manually disable your body cam? Silence, officer. Yes. Yes. What? Yes, I disabled it. Why? I don't remember. The device does not forget even if you do. Noted. Exhibit C, dispatch records. Adrian entered them into evidence personally. He read from the log. 0 robbery reports, 0 theft reports, 0 violent crime reports between the hours of 6 p.m. and midnight. He looked at Morales. Sergeant Morales, you told me I matched a description. Description of what crime? Morales stared straight ahead. Sergeant, you're under oath. I believe there was a report. You believed wrong or you lied. Which is it? Reed objected. Adrian sustained it. But the point was made. Exhibit D, phone call logs. Security footage from the jail showed 3 inmates making phone calls during Adrian's detention. Time-stamped, audio recorded, Adrian played the audio. 3 different voices, 3 successful calls. Sergeant Morales, you told me the phone system was down. Was that statement true? I thought it was. You thought wrong. Again, the jury, 12 citizens of the county, watched all of this. Their faces showed shock, confusion, anger. Then came Exhibit E. This was the bomb. Adrian introduced a statistical analysis. 5 years of arrest data from the county conducted by the 6th Circuit's data team. Dr. Sofia Ramirez took the stand. Statistician, Ph.D. from Stanford, expert witness. She presented her findings. County arrest data. Black drivers 8.7 times more likely to be arrested for suspicious activity. 12.3 times more likely to have vehicles searched. 6.4 times more likely to be held overnight without bail. Suspicious activity arrests of black individuals, 89% result in dropped charges or acquittal. Same statistic for others, 34%. Adrian let the numbers sit. The courtroom absorbed them. The jury absorbed them. Dr. Ramirez, in statistical analysis, what do we call a pattern this pronounced? Systemic discrimination, Your Honor. Adrian turned to Reed. Mr. Reed, does the county dispute these findings? Reed looked at his notes. He had nothing. We need time to review the methodology. You've had weeks. The methodology was provided. The county has had ample time. Do you dispute the findings or not? Reed sat down. No, Your Honor. Adrian nodded. He turned to the 3 officers. He looked at each one. Whitaker, Langley, Morales. Gentlemen, you have 2 choices. 1, this proceeds to full trial where every arrest you've made in 5 years will be scrutinized. Every traffic stop, every search, every report. 2, you accept a consent decree that includes your immediate suspension, mandatory bias training, and 2 years probation. Your employment futures will depend on your compliance and the county's reform measures. You have until after lunch to decide. Court is recessed. He struck the gavel once. The sound echoed. Adrian stood. He exited through the judge's chamber. The courtroom erupted in whispers. Whitaker sat frozen. Langley put his head in his hands. Morales stared at the bench where Adrian had sat. Reed turned to them. Take the deal. We didn't do anything wrong, Whitaker said. You arrested a judge without cause. Your body cams were off. You lied about a robbery. You denied him his phone call. A jury will convict you in 20 minutes. Reed's voice was harsh. Take the deal. Court reconvened. Reed stood. Your Honor, the defendants accept the consent decree terms. Adrian nodded. Let the record reflect that acceptance. Now we address the systemic issues that allowed this to happen. He read the terms aloud. Every word, every condition. Officers Whitaker, Langley, and Morales suspended without pay for 90 days. Then 2 years probation. Any citizen complaint triggers immediate review. Second violation equals termination. Sheriff Merrick not criminally charged, but must implement reforms or face removal proceedings. Department-wide bias training. All 47 county officers complete 40-hour certification, repeated annually. Body cam mandate cannot be disabled manually. Automatic activation when patrol car leaves station, footage cloud stored immediately, traffic stop data collection, race, reason for stop, duration, search conducted, arrest made, quarterly public reporting. The courtroom listened to every word. When Adrian finished, he looked at the three officers one final time. This consent decree is not punishment, it's education. You will learn what I learned in that cell, what it feels like to be powerless, to be disbelieved, to be judged before trial, and then you will learn to never make another person feel that way. Do you understand? All three nodded. Verbally, please. Yes, Your Honor, they said in unison. This court is adjourned. The gavel struck. Adrian stood. He exited. The room remained silent for 10 full seconds after he left. Then chaos. Reporters rushed out. Observers talked over each other. The jury filed out looking shaken. Reed packed his briefcase. He looked at the three officers. You just witnessed the most merciful verdict you'll ever receive. Don't waste it. He left them sitting there. Days after the hearing, the county commission held an emergency meeting. Adrian attended, not as a judge, as an expert witness. The commission chamber was full. County commissioners, Sheriff Merrick, community members, media. Commission Chairman Dale Porter called the meeting to order. 65 years old, farmer, 3 decades in local government. We're here to discuss the consent decree and its implementation. Judge Holloway has agreed to present a framework. Adrian stood. He carried a bound document, 47 pages, charts, data, policy recommendations. County Policing Reform Framework, he said simply. He distributed copies. Then he began. I'm going to present 5 structural reforms. These are not suggestions. Under the consent decree, failure to implement triggers state intervention. Let's begin. Reform 1, Civilian Review Board, 9 members. County residents, 3-year terms, reviews all use of force incidents and citizen complaints. 3 seats reserved for Black community members to ensure diverse perspective. Commissioner Ellen Rodriguez raised her hand. Who appoints them? The commission appoints 6. Community organizations nominate and elect 3. This prevents political capture. What's their authority? They can recommend discipline or training or policy changes. Sheriff must respond in writing within 30 days. If sheriff rejects recommendations, they can appeal to the state. Merrick shifted in his seat. He did not like this, but he said nothing. Reform 2, Early Warning System. Adrian pulled up a slide. Software interface, data fields. This system tracks officer behavior patterns, excessive force complaints, dismissed charges, citizen complaints, body cam malfunctions. Officers flagged after 3 incidents in 12 months trigger mandatory review. What kind of review? Porter asked. Psychological evaluation, retraining, possible reassignment. The goal is not punishment, it's intervention before patterns become tragedies. Sheriff Merrick spoke for the first time. Judge Holloway. With respect, this will create a culture of fear. Officers won't want to do their jobs. Adrian turned to him. Sheriff, officers who do their jobs correctly have nothing to fear from documentation. Officers who abuse their authority should fear documentation. That's the point. The room went quiet. Adrian continued. The data shows which officers generate complaints and which don't. Some officers work 30 years without a single excessive force complaint. Others generate 5 in 3 years. This system identifies the difference. Reform 3, Community Liaison Program. Every officer spends 8 hours monthly at community centers, schools, local events, not in uniform, not on duty, building relationships, not just enforcing. Deputy Chief Morrison spoke up. That's 64 hours per officer annually. We don't have the staffing. Then hire more officers or accept that policing is not just response, it's prevention, it's trust, budget accordingly. Adrian showed data from other departments that implemented similar programs. Crime rates decreased, community satisfaction increased, officer retention improved. When people know their officers as humans, not just badges, Cooperation increases, tips increase, de-escalation becomes easier. Reform 4. Financial accountability. This was the piece that made commissioners nervous. The county will pay a $250,000 settlement. I'm donating it to the Tennessee Legal Aid Society. But more important, your insurance premiums will increase due to this violation that hits the budget. That forces accountability. Porter frowned. Judge, we're a small county. Budget increases hurt services. Then don't violate civil rights. Insurance companies are excellent at risk assessment. They're telling you this behavior is expensive. Listen. Adrian showed the math. Average settlement for civil rights violations, $1.2 million. Training and prevention costs $80,000 annually. Prevention is cheaper than lawsuits every time. Reform 5. Mandatory reporting. Traffic stop data goes public quarterly. Race, reason, duration, search, arrest. No exceptions. Transparency creates accountability. He showed the county's current numbers, 8.7 times, 12.3 times, 6.4 times. These numbers are shameful. Publishing them quarterly will force improvement because nobody wants to explain why the disparity persists. Commissioner Rodriguez asked the hard question. Judge Holloway, do you believe our officers are racist? Adrian paused. The room held its breath. I believe they operate in a system with racial disparities. Whether that's explicit bias, implicit bias, or structural incentives does not change the outcome. Black drivers are arrested more often for the same behaviors. That's what the data shows. These reforms address the system, not individual souls. It was a careful answer. True. Measured. The commission voted 7-2. The framework passed. Merrick looked at Adrian. When do we start? Tomorrow. 1 week later, Adrian received a call from Magistrate Ellis, the man who had arraigned him. Judge Holloway, I need to speak with you. They met at a coffee shop outside the county. Neutral ground. Ellis looked tired, ashamed. I should have known, Ellis said. When you asked about Canon 3.2, I should have looked closer, asked more questions. I just processed you like everyone else. Adrian sipped his coffee. That's exactly the problem, Judge Ellis. You processed me like everyone else, but I wasn't everyone else. I was someone whose rights were violated, and you missed it. Ellis nodded. The Judicial Commission reprimanded me. Formal reprimand. 20 hours continuing education on constitutional rights. Good. That's it. Just good. Adrian leaned forward. Judge Ellis, you had one job that day. Protect my rights. You failed, not because you're malicious, because you're complacent. The system runs on complacency. The reprimand is fair. Learn from it. Ellis left, looking smaller than when he arrived. Adrian stayed. He ordered another coffee. Elena called. How'd it go? He apologized. Did you accept? I acknowledged it. Acceptance implies forgiveness. I'm not there yet. Elena understood. The data report comes out next month. Are you ready? Yes. The Tennessee Bureau of Investigation completed its review. The findings were released to the public. County Sheriff's Department pattern of discriminatory enforcement, insufficient oversight, inadequate training, systemic failures at multiple levels, recommendations aligned perfectly with Adrian's framework. Because Adrian had consulted on the investigation, his expertise, his experience, his data, the report went further. It recommended state monitoring. If disparities did not improve, the state could assume control of the department. Merrick read the report in his office. Alone. He was 58 years old, 3 terms as sheriff. He had never faced anything like this. He called Adrian. Judge Holloway, I need your help. I'm listening. I don't know how to fix this. The report, the numbers. I've been sheriff for years. This happened on my watch. Adrian was quiet for a moment. Sheriff, awareness is the first step. You're aware now. Implement the reforms. Actually implement them. Not for compliance, for change. Will you help? I'll monitor. I'll advise. But this is your department. You fix it. Merrick took a breath. Okay. Weeks after implementation, the first quarterly report was released. Traffic stops of black drivers decreased 42%. Suspicious activity arrests decreased 59%. The numbers were moving slowly, but moving. The Civilian Review Board held its first meeting, heard 4 cases, found in favor of officers in 3 cases, against in 1. The one case where they found against the officer, excessive force during a wellness check. Officer was suspended for 30 days, retrained, reassigned to desk duty for 6 months. The officer complained. He appealed. The state upheld the decision. The system was working. Adrian received letters, hundreds of them, from people who had been arrested in the county, from people across Tennessee, from across the country. One letter stood out from a mother in Memphis. Her son had been arrested 5 times for suspicious activity, never charged, never convicted, just arrested. Thank you for showing that the system can change. My son is afraid of police. Maybe now he won't have to be. Adrian kept that letter in his desk drawer. Whitaker resigned 4 months after the hearing. He could not handle the scrutiny, the oversight, the knowledge that every action was documented and reviewed. He moved to private security. He could not work in law enforcement again. The consent decree followed him. Langley stayed. He completed the bias training. He met with community members. He slowly, painfully, began to understand what he had done. 1 year later, Langley would become the department's community liaison coordinator. The transformation surprised everyone, including himself. Morales took early retirement. He was 46, 22 years on the force. He left quietly. Sheriff Merrick ran for re-election. His opponent used the incident against him, called him weak, said he had caved to outside pressure. Merrick won by 3 points. Narrow victory, but he won on a platform of reform. On election night, he called Adrian. I didn't think I'd make it. You earned it, Adrian said. Don't waste it. I won't. The reforms took root. The Civilian Review Board became a model. Other Tennessee counties requested the framework. Merrick presented at a state law enforcement conference. The body cam system worked flawlessly. Cloud storage meant no more convenient malfunctions. Officers complained at first. Then they realized the cameras protected them too. When complaints were false, the footage proved it. The early warning system flagged 6 officers in the first year. 3 were retrained successfully. 2 were reassigned. 1 was terminated for repeated violations. The traffic stop data told the story. Year 1, 8.7 times disparity. Year 2, 4.1 times. Still too high, but improving. Adrian presented the data at the National Judicial Conference. 1,200 judges attended. They listened. Data does not lie, Adrian said. 8.7 times. That number should haunt every person who says discrimination is rare or exaggerated. A judge from Alabama asked, what if the data is explained by crime rates in different communities? Adrian was ready. We controlled for that. We controlled for time of day, location, officer assignment, and reported crime rates. The disparity persists. Next question. The room went silent. Adrian continued. I did not want money. I wanted a mirror. I wanted these officers in this county to see themselves as I saw them that night. Data is that mirror. It reflects what we'd rather not see. The conference gave him a standing ovation, not because they agreed with everything, because he had forced them to look at something they had been avoiding. Adrian appeared on 60 Minutes. The segment aired. 18.7 million viewers. The interviewer asked the key question. Judge Holloway, did you ever consider physical resistance or legal aggression, suing for millions? Adrian's answer became the most quoted part of the interview. Violence would have confirmed their bias. A cash settlement would have enriched me, but changed nothing. I wanted structural change. I wanted policy. I wanted data collection that outlasts me. Protections that help people I'll never meet. Accountability systems that function when cameras are not watching. That's not revenge. That's citizenship. That's what the bench taught me. The clip went viral. 42 million views across platforms. Adrian received an invitation from the Tennessee State Legislature. They were considering Senate Bill 847, statewide body cam mandate. He testified. He brought his data. He brought his story. He brought his calm, devastating logic. The bill passed 28-5. Governor signed it. Adrian stood behind her at the signing ceremony. "This is Adrian's law," the governor said. Adrian shook his head in the photo. He did not want his name on it, but the name stuck. Law schools added his case to their curricula. Over 200 schools. Students studied the consent decree, the statistical analysis, the systemic approach. Adrian gave guest lectures, 6 schools in the first year. He talked about implicit bias, about data-driven reform, about the importance of lived experience. At Yale Law School, a student asked, "Judge Holloway, how did you stay so calm during your arrest?" Adrian thought about it. "I stayed calm because I knew anger would not help me. And I stayed calm because I was gathering evidence. Every word they said, every action they took, I was already building my case." Another student, "Would this have worked if you were not a judge?" Adrian's face grew serious. "No, that's the problem. My title gave me tools most people do not have. That's why the reform cannot be about protecting judges. It has to be about protecting everyone." Rosa Martinez, the gas station clerk, applied to law school. She had saved the security footage. She had testified at the hearing. Adrian wrote her recommendation letter. She was accepted to University of Tennessee Law School. Full scholarship. She called him crying. "I can't believe this." "I can," Adrian said. "You did the right thing when it mattered. That's what lawyers do." The 2 customers who filmed the arrest joined their local NAACP chapter. Both became police reform advocates. One ran for city council. He won. Judge Lorraine Bennett, Adrian's mentor, launched the Judicial Equity Initiative training program for judges, how to recognize systemic bias in their own courtrooms. 200 judges completed the training in year 1. Sheriff Merrick, despite everything, earned reluctant respect. He implemented every reform. He met with community leaders monthly. He published the data even when it looked bad. Year 3 data, traffic stop disparity down to 2.3 times. Still not equal, but moving. Merrick hired the county's first black deputy sheriff, promoted her to community liaison supervisor. The Citizens Review Board heard 47 cases in year 1. Found for officers 31 times, against 16 times. The board's independence proved its legitimacy. It was not rubber stamping either side. Adrian returned to the county 1 year after his arrest. He visited the gas station. The owner had renamed it Holloway Stop. Adrian had not given permission, but the owner, a Vietnamese immigrant, refused to change it back. "You changed this place," the owner said. "People are safer now. I honor that." He donated coffee sales to civil rights organizations, $15,000 in year 1. Adrian stood at the pump where he had been arrested, exactly where he had stood. He looked at the spot where Whitaker had approached. He felt nothing, no anger, no bitterness, just resolve. Adrian wrote an essay for The Atlantic. It began with this paragraph: "I have sentenced men to prison. I have upheld constitutional rights against government intrusion. I have written judicial opinions that create precedent for decades. But I have never felt the weight of injustice until I carried it in handcuffs. The judge's robe creates distance, necessary professional distance from the defendant's reality." That night stripped away the distance. "I stood where thousands stand daily, powerless, disbelieved, and judged before trial. The difference? I had tools to fight back. Most do not. Reform must be the bridge." The essay went viral, 3 million reads in the first week. Adrian continued his work. He testified before Congress on police reform legislation. He consulted with 12 cities on implementing civilian review boards. The Holloway Fellowship was established at University of Tennessee. 12 young black law students received full scholarships annually. Adrian mentored each one personally. One fellow asked him, "Do you regret driving through the county that night?" Adrian smiled. "I regret that it happened. I do not regret what came from it." The phrase Holloway Standard entered the reform lexicon. Data-driven police accountability. Other Tennessee counties adopted similar frameworks voluntarily. 14 counties by year 2. Georgia, Alabama, and Kentucky requested Adrian's framework. The U.S. Department of Justice cited county reforms in guidance documents. A documentary was made, The Judge and the System, PBS. It won an Emmy. The film ended with Adrian returning to his courtroom in Atlanta. Business as usual, except nothing was usual anymore. Every defendant who stood before him now stood before someone who had been in their position. Not metaphorically, literally. Adrian's sentencing changed, more nuanced, more aware, more just. His colleagues noticed. Judge Bennett asked him about it. "You're different now." "I am," Adrian agreed. "I understand what I could not before. The fear, the helplessness, the knowledge that the system can fail you, even when you have done nothing wrong." "Are you glad it happened?" Adrian considered this. "I am glad something good came from it. I am not glad it was necessary." The gas station became an unofficial memorial. People left flowers, signs, messages of solidarity. One sign read, "Justice here." The station owner kept it up. Adrian's story was taught in 200 law schools. His calm mugshot became a meme. The caption, "When you're not mad, just disappointed on a constitutional level." Adrian found this funny. Elena did not. "They're trivializing what happened to you." "No," Adrian said. "They're making it accessible. If a meme gets a 20-year-old to think about civil rights, I'll take it." 3 years after his arrest, the county released its data report. Traffic stop disparity 1.8 times, nearly equal. Not perfect, but approaching it. Citizen complaints down 61% from pre-reform levels. Community trust survey. 73% of residents reported increased confidence in police. Adrian read the report in his chambers. He called Merrick. "You did it." Merrick's voice was tired but proud. "We did it. You gave us the map. We followed it. Keep following it. I will." These are the kind of real-life stories that remind us change is possible. Black stories like Adrian's prove that touching stories do not require violence to be powerful. Beat stories, the kind that show systems being challenged and reformed, offer hope. Adrian closed his essay with these words. "I was arrested for nothing, and that nothing became the foundation for something. This is not a story about one man's vindication. It's about the thousands of nothings, the stops, the searches, the suspicions, the handcuffs without cause that happen when cameras are not rolling, when judges are not wearing suits, when no one with power is watching. We watched this time. Now we build systems that watch always." His final message to everyone who heard his story. If this story moved you, do not let that feeling dissipate when you scroll past. Here is what you can do. Comment below about a time you witnessed or experienced injustice. Silence protects systems. Stories expose them. Your voice matters. Share this video. Someone in your network needs to see that quiet resistance can reform systems violence never could. Transformation spreads through sharing. Research your local police department's traffic stop data. Most cities publish it. If the numbers look like the counties did, attend a city council meeting, ask questions, demand answers. Subscribe to this channel. We tell real-life stories of power confronted, systems changed, and dignity defended. Black stories, touching stories, beat stories that matter. The gavel Adrian carried that night was not just his. It belongs to every person who refuses to accept that's just how things are. Now it is your turn to pick it up.